Hi there, can you hear me?
Hey, Megan. Yep,
Hey,
this is Dana. Can you hear me?
I can.
So I'm just gonna say that I just came in and then left again. And when I came in the last time, there were two attendees in here that were like just random people, like registrants.
Oh,
So there's no waiting room, I guess.
well, that's strange. Okay.
I know. I know. I
Um,
went back
I
into
know
try to look at the
the setup.
setup. Yeah. Word. And I couldn't see anything. But I think we
Um,
might. I think we might be on.
yes, I believe we are. Um, so
All right, so Amy's
I,
gonna join in a minute. Amy will put her slides up and share her screen, and we're just gonna work off of that.
okay, great. I know we were looking to potentially stream this, and we did do that with a PAFNNN event before, but I think I had to
be talking a little bit about services for people who are in what's called the Community Health Choices Waiver, which is for adults, and services like keeping and retaining home care, personal assistance services, or continuous nursing services. That is a huge part of our work, is access to these types of services. And the way we help people is we have a helpline for clients. And through that helpline, we provide advice as well as direct legal representation. We serve all Pennsylvania counties. There are no exceptions. We serve the cities, we serve the rural communities as well. And our services do not have an income limit to qualify. So there's no hard cutoff for accessing our services. We also do technical assistance, and we do this for providers of services as well as for other advocates and other legal services organizations. And this is so that we can make sure that we're sharing the knowledge we've obtained from our years of work in this area so that others can do self-advocacy or assist friends, neighbors, or other clients in accessing services. We do community education and training, like this training, as well as self-help materials. So we do actually have some guides that give an overview of the appeals process that we'll be discussing today on our website, as well as other guides to Medicaid eligibility and accessing services. We do a monthly email newsletter, and that is really focused on updating people on policies that affect healthcare and health access in Pennsylvania. And we do a large focus on Medicaid because that's really where our work is, but we also look at what's going on federally as well. So sign up for the newsletter. It's where we will update you on any upcoming trainings as well. If you click on the slides, which we will share after the training, you can access them by clicking the little here link on this slide. Finally, we do policy advocacy, and this is really to increase access to health coverage and services, primarily in Medicaid. And Dana and I actually do a lot of this policy work. She and I sort of share doing work. I do some of the adult access to waiver services, and Dana does access to services for children. We meet with the state regularly. We advocate for policy changes. During COVID, we advocated for a lot of policies that would help people retain services so that they were more stable during this crisis. So that's another large part of our work. And we both do all of the work, but I think today, especially with Dana, who has done a lot of work with people under 21, you're really lucky to have such a great presenter who has such a deep knowledge of this area. So what we're going to do today is go over what Medicaid managed care is. And I'm going to tell you that we're going to start with that, but that's what this presentation is really about. It's about appealing service denials in Medicaid managed care. And then we're going to go over what is entailed in an appeal, because it's not a single step process. We're going to talk about 3 of the steps in the process. Those are a grievance, which is an internal appeal, an external review, which is another type of appeal, and a fair hearing, which is usually the last stop for most appeals. And then again, as Megan indicated, we will end with questions. So let's talk about Medicaid managed care and give a brief overview. First of all, when we talk about Medicaid, you may hear people say MA or medical assistance. That's all the same thing in Pennsylvania. Medical assistance, Medicaid, MA. It's just sort of depends on who you're around and what jargon that you've adopted. But officially, it's medical assistance if you're looking into some of the regulations. So you'll hear it interchangeably. So in Pennsylvania, Medicaid is delivered through two different systems. And this is when I say delivered, I mean the services. So it's one thing to get on Medicaid and be eligible, but it's another thing to be able to access the services like the nursing services or dental services or doctors. So there's two systems. One is called fee for service, and that's when the state pays the doctor directly when you go to the doctor or when you go to a provider. And that's it. It's pretty simple. The state negotiates the contracts. They decide what services you're going to get, and the doctor gets paid or the provider gets paid. But there's another system in Pennsylvania, and it's actually the larger system, and it's called managed care. And it's really how most Medicaid participants in Pennsylvania get their services. What happens is the state pays private insurance companies, which we call managed care organizations or MCOs, and they pay them a monthly rate based on the number of people who are enrolled in their plan. And then that plan is in charge of administering all the Medicaid benefits. The plan decides who is going to be in its provider network. So some providers of services may be in the network, some may be out of network. If a participant wants to get a service, they have to go to an in-network provider, unless there's sort of exceptional circumstances. And then the managed care organization is in charge of paying that provider and deciding what amount to pay them, and also what services the participant is going to get. All of the managed care plans in each program for Medicaid in Pennsylvania cover the same services. So it's not like people in managed care are going to get less services because they enroll in UPMC as opposed to enrolling in Gateway. It's all the same service package. But what happens is the managed care plan becomes the gatekeeper for the services. So when somebody wants a service, a lot of services are prior authorized, which means you need permission to get the service before you can get it. And the plan will review the request for the service and decide yay or nay. So they'll say, yes, you're going to get the service. No, you're going to get the service. Or maybe you'll get half of the service. So that's really how managed care works. And it's not all that dissimilar to how a lot of people get their insurance. So, you know, in the private insurance and commercial market, really, we are all using health insurance programs for the most part, health companies that make decisions about what care we're going to get. So in Pennsylvania, the way the managed care system is set up for Medicaid is the whole system is called health choices. But there are actually 3 different types of health choices plans. There's something which we generally just call health choices, which is really a plan that covers the physical health benefit of Medicaid. So for adults and children, most people in Medicaid are going to be in a health choices plan, and that's where they're going to go get their primary care physician through. That's who's going to cover their specialist services. That's who's going to cover any kind of testing, durable medical equipment, prescription drugs. And for people who are under 21, that's where they're going to get access to shift nursing and home health aid services. Another type of managed care plan in Pennsylvania is called community health choices. This actually combines all of the physical health benefits and what we call long-term services and supports, which is nursing facility care and home and community-based services. So home and community-based services include things like, for adults, community health choices are only for people 21 and over. This is how adults are able to access shift nursing and personal assistance services, home health services in their home. So it really takes the physical health benefit and adds on what we call a home and community-based service benefit for adults. There's a separate eligibility to get that extra piece of home and community-based services. But this is where people who are on both Medicaid and Medicare will go to get their physical health services. And then people who are in nursing home will get their nursing home services too. And then people who are eligible for home and community-based services through a waiver will get these extra benefits, these extra services, which include as I said, the shift nursing, personal assistance services. There's home modifications. There's a whole list of services. Finally, to make things a little confusing, there is behavioral health choices. And these are managed care plans that only cover mental health and mental health services and substance use disorder services. What happens is these work alongside the other types of health choices plans, the CHC or the physical health choices, or even people who are in regular fee-for-service Medicaid where the state's paying directly. So you'll notice earlier when I talked about physical health choices and community health choices, I did not talk about behavioral health services. They are carved out and in a separate health choices plan. And just so you know, people don't really have a choice of behavioral health choices plan. It's based on what county you live in. But for the other health choices plans, there is a choice. For physical health choices, there are 8 different plans. They're not all available in every region, but overall there are 8 plans, and I believe there's about 4 in each county. And for community health choices, there are 3 options in each county. PA Health and Wellness, UPMC, and AmeriHealth or Keystone First. They're really the same company for purposes of community health choices. They just have a different brand in different parts of the state. So now let's have a brief overview of appeals, and then Dan is going to get into a little more of the nitty-gritty. So an appeal is a general term for the process of asking or for challenging a decision that is made by a managed care plan in this context. So what we say is we're appealing a service denial. If somebody is denied shift nursing, we're going to appeal that decision. We're going to challenge it and ask that that decision be changed in our favor. There are 3 types of appeals, all of which we're going to go into more detail. There's the grievance, which is the plan internally deciding whether its original decision was correct. So it's really reconsideration of their original decision. There's external review, which is when an independent doctor looks at the same information the plan had and decides whether it agrees or disagrees with the plan. And then there's a fair hearing, which is more like a, it's like court proceeding, but very light on the court proceeding side. People are sworn in, you have to, when you testify, you're under oath. It's a judge who's hearing it, but it's an administrative law judge. It's not a judge who's necessarily an attorney. And both sides argue their case, and the judge makes a decision about whether that judge agrees or disagrees with what the managed care plan did. So to understand the appeal framework in managed care, it's a little complicated. It's not like, if any of you know Medicaid eligibility, it's not like I get a Medicaid denial, I appeal to a fair hearing, and that's it. It's not a straight line, though it is a multi-step process. So it starts with a denial. After that, you file what's called a grievance, which is the internal appeal, and you have to file that in order to get to any other stage of the appeal process. If the grievance is not in someone's favor, they have a choice of requesting external review and or a state fair hearing. And I say and or because you can choose one or the other. We often go for both, and there's a few reasons for this. One is depending on the type of case it is, we've had pretty good luck at external review, and that if an independent doctor decides that they disagree with the plan, then case closed, it's over. And that process goes a little faster than the fair hearing. But the fair hearing is also another bite at the apple, and it's really a chance to persuade a judge, and you get to be in person. But the other thing is, we're going to talk about this in a minute, is you want to be able to keep your benefits going if you're experiencing a cut in services. So I will talk about that in a minute. And the only way to do that after a grievance is to really request both a fair hearing and external review. I want to just make a quick plug on what's going on during COVID, because appeals are a little different, and what people should be challenging right now may not be all of the things you would challenge in a non-COVID environment. So there's a link when you get these slides to a provider quick tip. Basically, during COVID, for children under 21 who are getting skilled nursing services, so shift nursing, there's no prior authorization required to continue getting them. So if somebody's getting 8 hours of shift nursing 7 days a week, they should be able to continue getting that during the COVID emergency declaration. Also for home health aid services, which is something that's available for people under 21 as well as over 21, but less utilized because it's a short benefit. It doesn't provide ongoing home health, it's just intermittent. But for that, for the first 28 days, there's no prior authorization. What this means, and primarily for the shift nursing for people under 21, is that you should not be seeing denials of prior authorizations for ongoing shift nursing. So if you see that, you should contact PHLP, because we would want to know and that we can do some advocacies. So, and it may not be automatic. So that's why we want to hear from you if there's a problem. Now, I want to just note this does not apply to continuous nursing in the home or personal assistance services and community health choices. There was a time where those services couldn't be cut during COVID, but that time has ended as of the end of June. And when I say services can be cut, I mean can be cut and they are being cut. So that's where the appeals process comes in. All right, so why would you want to appeal? First of all, you should never assume that a denial is appropriate. There are lots of times where an MCO, first of all, makes a mistake, and second of all, just doesn't have all the information or is making a decision that's not correct or not based on the right standards. So you should appeal if you do not think that the MCO made the decision that you feel you should have gotten. So if you have a child who's getting shift nursing in the managed care plan and you ask for more because there's been a change in your circumstances and the plan denies, appeal, just appeal. So the other thing is to know for kids, MCOs have to approve all of the medically necessary services. It's a really broad definition of medical necessity for kids. And the definition shrinks right up when you're an adult, but as for kids, it's really accessing services that help kids, especially medically complex kids, should be something that we fight for, and it is winnable. I'm not saying you'll always win, but it's worth challenging because the definitions of what is necessary are very favorable to kids. In community health choices, the waiver services like continuous nursing at home or personal assistance services also have a broad medical necessity definition applied to them. The other thing is, if you're experiencing a cut in a service or any kind of reduction, you can continue getting that benefit while you appeal if you appeal on time. We are here to help. Our assistance is free. And we just want you to know that we will advise, we will represent, but we don't want you to take no for an answer. So there are three types of denials that you may come across when you're talking about things like personal assistance services or shift nursing. You may see a service that's denied completely. You ask for, 20 hours a week of personal assistance services, and the plan says, no, you get 0. That's a complete denial. Sometimes you can get services that are approved other than as requested. So you ask for 8 hours a day, 7 days a week of shift nursing plus an additional 4 hours overnight each night, and the plan doesn't approve the overnight, but approves the daytime hours. That's approved other than as requested. And then there's services that are denied as requested, but a substitute service is provided. So we don't see, well, actually, we'll do see this some, but you might see somebody who requests continuous nursing, and the plan says, we're not going to give you nursing, we're going to give you personal assistance services instead. That's one example. All of these, though, are denials, and all of them can be appealed. So there are a number of appeal rights, and this includes the right to written notice, which has to be sent 10 days in advance if a service is going to be cut. So that's important because that means you should hang on to the envelopes and always check any mail from the MCO and check to see if the date on the letter matches the date on the envelope, because if it doesn't, you have 10 days from the mail date. You have the right, as I said earlier, to continue getting the service at issue as long as you appeal within 10 days of the mail date on the denial notice or prior to whatever the effective date of the decision is. This is really important. 10 days, not a very long time, especially when we've seen a lot of mail delays. So keep the envelope. If you have an issue, especially on the CHC side, we've been able to sometimes get people the continuing benefits. We call it aid paid pending when they appeal late, if there have been some issues with the mail recently. But it's a really critical benefit to maintain, because if you can keep your benefits while appealing, then you can relax a little during the appeal process, knowing that there's several steps and it's not going to be an immediate cut in services. And this, the right to aid paid pending applies at all levels of the appeal. You have to file within 10 days of a decision, but it applies at each level. So remember earlier when I said request external review and a fair hearing? You want to do them both at the same time within 10 days of the underlying decision. Because if you wait, I'm going to go back really quickly. If you have a grievance decision and you say, okay, I'm going to do external review, and then if that doesn't go in my favor, then I'll request a hearing. Well, if you were getting 50 hours of personal assistance services that are being cut to 25, and you request the external review and it doesn't come in your favor and you didn't request the fair hearing, guess what? Those services are going to get cut while you're waiting for the fair hearing if you didn't request it right after the grievance. So I can't emphasize that enough because it's honestly really confusing. Okay, we've included a sample denial notice in the slides that you can look at, and this is a sample denial notice where it's approved other than as requested. But I want to focus in on some of the language. There's two ways you might see this continuing benefits language. Sometimes it's written where just it's kind of like a paragraph that just like works its way into the end of a description of the denial. And it will say something like the current hours you've been getting will end on such and such date, and then it gives you a deadline to file the grievance. There's also sometimes you'll see a language where it just says you have to file within 10 days of the date on this notice. So really look out for that language, but what you're keyed into is the date on the notice and the date on the envelope. Okay, I just want to say a quick thing. We've seen this more on the shift nursing side for kids, but when you appeal, if you get a decision like you requested 8 hours of nursing a night, 7 days a week, and 4 hours a day, Monday through Friday, and the MCO says, I'm approving this other than as requested, we're going to approve the nursing hours at night, the overnight hours, but we're going to deny the daytime hours. during the appeal, just because you're appealing, it doesn't mean you can't get what was approved. So the person appealing this decision will get the 8 hours of overnight, and then they're just appealing for the additional daytime hours. And there has been some confusion about this, even amongst the plans. So that's why we're highlighting it here. Okay. So quickly on the grievance. So this is your internal appeal. My overview is just a couple things I want to say about it briefly, and then Dan is going to get into it. But it's a request to reconsider the decision, as I said before. And the plan has 30 days to decide, although it can be extended another 14 days if the participant asks for a longer time before the grievance decision is made. And there are multiple people who can request this. So this includes a participant, their power of attorney, their legal guardian, which could include a parent if the person's a minor, a healthcare power of attorney or agent, a healthcare representative, which is if a doctor determines that somebody isn't competent, a healthcare representative can be appointed by law. It's a pretty easy process. You just need a doctor to say somebody's incompetent. This is like our last resort, but sometimes we've had to go there if it's true. And then anyone the participant designates in writing, including a provider. If anybody else tries to appeal, there's a chance the plan will reject the appeal. So if you have a problem where you don't think anyone's authorized to request an appeal and the plan's giving a hard time, call us and we can try to work on that issue. As I said earlier, you have to request an appeal within 10 days to get the benefits continuing. Otherwise, there's 60 days to request the appeal. And that's, so you would want to do the 60 days. Just keep that in mind that we don't see people relying on waiting 2 months very often. But if it's a request for an increase, you might want to make sure you have all your evidence together before you appeal. And it can be done by phone, fax, or mail. Save copies of fax receipts. We really want people to mail things certified because we hear too often that an appeal can't be found. And if you call on the phone, please document the date and time of the call, ask for a reference number for the call, and even follow up with a confirmation letter. There is also a grievance request form that you can use, which covers all the things you're going to want to put into any kind of request. So if you don't find this form, it should be in every grievance, in every denial. But if you've lost it for some reason, you can just write to the plan and say you want to file a grievance. You say what decision you're disagreeing with. All you have to say is, I disagree. You don't have to go into a long explanation. Let the plan know you want the services to stay the same. You want to let them know how you want the grievance review, because there will be a review. Request all the information the MCO used to make its decision, and let them know whether someone will represent you and who that is. After the grievance request is put in, the plan is supposed to send an acknowledgement letter upon request. This is usually supposed to be 5 days, describing the issue. And if you disagree with how it's described, you should ask them to amend it. It also explains the grievance process. And then the next communication you're going to get should be a letter sent at least 10 days before the grievance review meeting, scheduling the grievance. It's going to tell you how to attend and when and where if you're doing it in person. And while you're at that grievance, so this grievance is going to happen with a panel of people, you're going to, you have a right to have a representative, and you have a right to present evidence and arguments as well as witnesses. But if you want to participate and explain your case to the managed care plan, you have to let them know that, because they will hold that grievance without you. And we've seen it happen. We've seen it happen even when people asked to participate, and we've had to cure that. So Dan, I'm going to turn it over to you.
Great, thank you, Amy. All right, so I'm going to get into a little bit more detail about what you want to show at the grievance and go through some more of the nitty-gritty stuff. So first, the main thing you really want to show at the grievance is why you need the service or item that's been denied. And it's not just showing, why it would maybe benefit your life, or, it's not just sort of an open-ended, I need this service. You want to show how the service or item that's in question meets the medical necessity definition, which we'll go through on the next slide. Now, that's a legal definition. It's found in state regulations. The important takeaway, even though the title is medical necessity, you want to remember that the service or item itself doesn't need to be medical. So some examples are things like personal assistance services. Those are not necessarily what you would think of as medical, but you're still showing that they are, quote, medically necessary. Non-medical transportation is another example. That's clearly not a medical service, but it's something that you need to show is medically necessary if you want to receive the service. Next slide, Amy. Great. So this is the definition of medical necessity that is applicable to children under 21 who are trying to get services, as well as adults who are in the Health Choices program who do not receive waiver services. On the next slide, I am going to talk about the waiver service definition because it differs a bit by adding one additional prong. But this three-prong definition here on this slide is the definition that you want to meet if you are a child under 21 or you're an adult. So let's say you're trying to get like a prescription approved as an adult and you want to show it's medically necessary. So will the service or item prevent the onset of an illness, condition, or disability? Will the service or item reduce or ameliorate the physical, mental, or developmental effects of the person's illness, condition, injury, or disability? Or the third prong is really applicable to sort of personal care or personal assistance, home health services. Will the service assist the participant to achieve or maintain maximum functional capacity in performing daily activities? So when we talk about kids who need home health aid services, for example, maybe they have a developmental disability that requires some help with bathing, dressing, toileting, meal preparation and eating, those types of things, those daily activities. So if you can show that the service meets one of those three prongs, then it should meet the definition of medical necessity and it should be approved. It's enough to just meet one. Go ahead, Amy, next slide. And this prong here, as I mentioned, is the additional standard that's available to participants who are in community health choices receiving long-term services and supports. So in other words, waiver services. So will the service provide the opportunity for the participant receiving LTSS to have access to the benefits of community living, to achieve person-centered goals, and to live and work in the setting of their choice? So let's say that somebody needs personal assistance services in order to be able to get to work and thrive in the community. That's an example of how you would show that personal assistance services are medically necessary because they meet prong number 4. They will allow the individual to work in the setting of their choice. That's just one example. So that's what you're trying to show at the grievance. We're going to shift gears a bit. We're going to talk about how do you get an expedited grievance? And that's important because if you're waiting the normal time frame, which is 30 days for a grievance decision, that could be harmful to your health. I just pause and note on this slide that you're not going to want to pursue an expedited grievance. And for that matter, you're probably not going to be able to get an expedited grievance if you've got continued benefits pending appeal or that aid paid pending that we talked about. There's going to be no reason why you would want to have an expedited grievance in that situation because you've got the benefit of continuing those services so long as the grievance is going on. So who cares if it takes 30 days if you've got the services in place in the meantime. But let's say you miss that 10-day window and you have no services while you're waiting. This is when you're going to want to think about doing an expedited grievance. And this is something that plans don't always highlight. They don't make it very easy to get these. So there may be some advocacy involved. You might need to call the Health Law Project for assistance here. What you're going to need to do is submit a letter from your doctor showing that waiting the normal time frame would place your life health, or ability to attain, maintain, or regain maximum function in jeopardy. So waiting that normal time frame is going to be harmful for you in one of these ways. We've seen the plans try to say that it needs to be, quote, life or death. That's sort of where they put it. That is not appropriate. That's too narrow of a standard. If you can show that just waiting the normal time frame would meet this standard, you should be able to get an expedited grievance. But note that you do need to have the doctor put that into a letter. Some plans do have expedited grievance provider certification forms that they want you to fill out. But in that case, even if the plan does have a form, I would argue you should still be able to use a letter from the doctor. But again, doctors sometimes like forms. So if you can get your hands on a form that the plan uses, then that's even better. And then final note on the expedited request, the Health Law Project has template letters that we can provide. So it's sort of a fill in the blank for the doctor that has this exact standard in it. And then the doctors don't feel like they're, unclear on what they need to write. Next slide. So to prepare for your grievance, there are a few things you want to do. First, you want to request a copy of all the documents and information the plan looked at to make their decision. You have a legal right to get this information free of charge. You have to ask for it though, but once you do make that request, the plan must provide it to you free of charge. As Amy noted, we see some problems with plans honoring requests that occur after the grievance. So, I want to participate in my grievance. I want to see all the information that was used to make the decision in this case. Sometimes you just don't get the file when you ask for it. So there may be some advocacy that needs to be done there. One thing I'll note is to just keep following up with the plan and say, I still have not received the file that I asked for with my documentation and information that you looked at. Please send it to me. But if that still doesn't work, then call the Health Law Project and we can try to navigate that for you. When you're preparing for the grievance, you also want to be thinking about what additional documentation would help make the case that your services are medically necessary. So can you get a letter from your doctor? Can you get some care logs from your personal assistant to show what services they're providing to you on a daily basis? In the nursing context, the nurses, of course, are taking nursing notes, so you'll be able to get those generally from the home health agency. Anything that's going to bolster the argument that these services are medically necessary should be submitted to the plan ahead of time. So if you're going to the grievance in person, which we really are not seeing right now due to COVID, but if you're going in person during non-COVID times, just bring the documentation with you. Have 2 copies, one for yourself and one for the plan. But if you're going to participate in the grievance by phone or by video conference, you need to get that information over to the appeal and grievance office ahead of time. They should make the information available to you in terms of how to contact them to submit that information, but we have appeal email addresses and fax numbers where appropriate. So if you need those, you can reach out to us. Next slide. So at the grievance proceeding, what's going to happen is, I'm sorry, let me rewind. Before the grievance, one other thing you want to do when you send over your documentation is to say, I am planning to participate in my grievance, but I also would like to have this witness or this representative participate with me. And here's their name and here's their phone number. So what they're going to do is schedule, if it's a telephone grievance or a video conference, they're going to give you the contact information ahead of time. So usually what they'll do is give you like a Zoom login or a conference line phone number that you dial with an access code. Sometimes the plans will actually just hold it as a conference call where they just keep adding people into the phone system. So sometimes they won't give you that dial in information ahead of time. Sometimes they're just going to say, all right, I need the phone numbers of everybody that's going to participate. So then they can make a big conference call for everyone. It should be clear from the scheduling notice which they're doing. So at the grievance itself, there's going to be a panel of 3, sometimes more, people who have not been involved in the initial decision or who are not a subordinate of the initial decision maker. So if the initial decision maker was the chief medical director for the plan, then all the other medical directors that work under that doctor are essentially mooted out. They should not be participating in that grievance. And then obviously the same doctor that made the initial decision should not be participating in the grievance. The idea is that it's a fresh bite at the apple. They're seeing it from with fresh eyes. The panel has to include a physician who is in the same or similar specialty as the physicians that typically manage or consult on the service or item at issue. So something we've seen and something to keep your eyes out for is if the plan has, let's say, an OB/GYN is deciding the grievance for a request for nursing services for a child. That is not the same or similar specialty as the type that typically manages or consults on nursing services. So that's inappropriate and something that you should call the Health Thought Project about, and we can try to cure that problem. The physician at the grievance is the ultimate decider. So there are 2 other members who participate in the grievance proceeding. It's going to be one person who's a non-employee voter. Sometimes it's an independent contractor. Some plans use members of the plan. They just have to be someone who is not employed by the plan. And that's supposed to be their stab at impartiality for the decision. And then the third person is usually like a nurse or something like that, somebody who works for the plan. But those 3 people are going to get together after the grievance and decide the case in combination with the physician. But that physician really holds the cards. He or she's the ultimate decision maker. Something else to keep in mind is that if you go in person to a grievance, at least one committee member has to be physically present in the room. So of that 3-person committee, you can't just have everybody participate by phone or have everybody on video conference. We have actually seen clients go to an in-person grievance and they walk into the room and everybody who's actually making the decision is on a conference call. That's not appropriate. So one person at least has to be physically present and everybody else has to participate by video conference. Next slide. During the grievance proceeding, what you want to do is be prepared to present your case. Explain through your witnesses, so people who speak on your behalf, and documents that you submit, how the service is medically necessary. Don't let the managed care plan put unreasonable restraints on how long you have to present your case. So we've seen the plans try to say that you only have 5 minutes. That is not appropriate. Legally, you're entitled to a reasonable opportunity to present your case at the grievance. So if that happens, what we suggest is just saying, respectfully, I will need more than 5 minutes to present my case, and try to just go on from there, but sort of stand up to that if you can when they say something, or if they say something like a limiting time to present your case. They may ask questions of you. So once you've gone through your explanation of why the service is medically necessary, sometimes they have clarifying questions. Sometimes they have no questions and it's complete silence, which can be nerve-wracking. But we've seen pretty similar outcomes regardless of how engaged the plan is. So, don't panic if there are no questions, because sometimes that just means that you've explained everything that needed explaining. Usually the proceeding lasts about 30 to 60 minutes total. If you have somebody participating, like a nurse or somebody like that, who you want to help you out and participate in the grievance with you as a witness, just let them know to block off about an hour max. We don't usually see them going longer than that. And the proceeding is recorded or it's transcribed. So there is a record created at that proceeding. Next slide. So under normal circumstances, you should get a decision in no more than 30 days from the date you requested the grievance. That deadline can be extended at the participant's request by up to 14 days. So the plan itself, the MCO, cannot extend that 30 days. beyond the 30 days, excuse me, but the participant can say, I would like more time, and they can ask that it be extended up to 14 more days. They're going to mail the decision within 5 business days of the grievance meeting, or they should mail the decision within 5 business days. So you don't find out on the spot in most circumstances, which, it would be nice if they would tell you right away, but sometimes they do. Sometimes they say, I've heard enough, we're going to approve the service, but that's rare. Otherwise, you'll get the decision in the mail. So look out for the mail after the grievance decision. A copy must go to the legal representative as well, the person designated as the representative. We've seen some problems with the plans only providing the decision to the participant themselves and not to the representative, which poses some barriers and problems. So that's not appropriate. If you got an expedited grievance, which means your provider submitted that certification and the plan said, okay, that's sufficient, we think you need an expedited grievance, we're going to give you one, then you get a decision within 48 hours of receipt of the provider certification, or within 72 hours of when you request the expedited grievance, whichever time frame is shorter. So it's a very quick turnaround. When you have an expedited grievance, you are going to get generally a phone call, or they will tell you the decision in person, but they still have to send a written decision within 2 business days. And again, your representative also has to be notified orally or in writing. Next slide. So if you win at the grievance, you're going to get a letter that says the denial was overturned, which is great. The managed care plan is bound by that decision. They have no right to appeal the decision of their own grievance committee. If they fail to promptly implement their own grievance decision, so let's say you get the service approved and then nothing, you don't actually get the service coming to you, contact the Health Law Project and we can try to expedite that and get that implemented for you. Unfortunately, grievance decisions are not binding on future requests for the same service, so there's no precedent set here. At the next prior authorization or the next service review that you have, you are going to be open to a denial again, and you may need to go through the process again. It's not common that we see that, but it can happen where you've just fought this battle through the grievance and then you get another service denial for the same service 6 months or 12 months later. Next slide. If you lose at the grievance, you're going to get a letter that says the denial was upheld. And here's where, as Amy mentioned, you have the right to request the external review and the DHS fair hearing. You can do one or the other, but we recommend doing both. And you want to file both of those appeals within 10 days of the date on the grievance decision in order to make sure you have the right to the continued benefits pending the appeal. So pending the outcome of both the external review and the fair hearing. And we'll get right into what those are all about. There we go. Next slide. We're going to start with the external review. This is a review by an outside agency called a certified review entity that's in normal circumstances is assigned by the Department of Health. The certified review entity is going to review the managed care plan's decision and decide if it was appropriate or not. Right now, during COVID, the plans are actually assigning their own certified review entities. So it's still an external organization. It's still from the same list of organizations that the Department of Health was using previously. It's just taken that Department of Health assignment step out of the equation. So that's just a temporary COVID change right now. To request an external review, put it in writing to the plan, or you can call the plan within 15 days of the grievance decision, or as always, within 10 days to keep services in place through aid paid pending during the review process. The managed care plan is going to send a case file out with everything from the grievance. It should be the transcript of the grievance, the outcome of the grievance, anything that was submitted in support of the grievance, so any doctor's letters, anything like that should go to the certified review entity. However, You as the participant are only going to get a list of what the plan sent to the certified review entity. You're not going to be able to actually make sure that everything you want is in that file. So anything you want the certified review entity to look at when they make their decision should be sent directly to them with a copy to the managed care plan. If you don't send a copy to the managed care plan, the certified review entity can disregard it entirely. Now for the external review, there's no meeting held. It's just a paper review of documents. Next slide. All right, so I just mentioned this piece here. The important takeaway, the managed care plans are assigning their own certified review entity. What we've seen that mean is, under normal times, you would get a letter saying, here's the certified review entity that the Department of Health has assigned. Here's how to submit new information to them. We're not seeing that always go out right now. So stay on the plan, keep following up with them, and request what information you need from them to send information to the certified review entity. And make sure you submit your additional documents to the certified review entity within 15 days of the date on the CRE assignment notice. That's a notice that you should be getting that says, here's the certified review entity that has been assigned to review your case. Next slide. All right, I'm going to go through the last pieces a little bit quickly so we can make sure we have time for questions. Note the external review timeline is 60 days to get a decision. There is an expedited external review available. It has the same harm standard that we talked about for the expedited grievance. If you win at the if you win at the external review, the plan is bound by that decision and has to provide the service, just like the grievance. The participant or the plan can appeal an external review decision in court. It goes to Commonwealth Court. It does not go to a fair hearing. All right, moving pretty quickly here. We just want to make sure we have time. We're going to go to the Department of Human Services fair hearing, which we mentioned, that's pretty much the last stop of an appeal for most people. This is a proceeding before an administrative law judge from the Department of Human Services. All other things being equal, the fair hearing is basically your best shot at getting the denial overturned because you're arguing before a completely neutral decision maker who is trained in the law and understands the regulations. They're not always lawyers, but they are familiar with the regulations and the laws that are applicable here. So they know the medical necessity definition. And if you're not successful at the grievance, we do see a lot of success at the fair hearing. So sometimes, it's just sticking it out and going forward with the appeal through the end. To request the fair hearing, you have to postmark the request. So it has to be in writing. You can't request it by phone. Postmark that request within 10 days of the grievance decision mail date to keep receiving the 8 paid pending services for existing services. Or otherwise, you have 120 days to postmark your request, and that's 120 days from the grievance decision notice. You want to hang on to the envelope from the grievance decision in case it was mailed late. We are seeing that happen a lot more frequently now, especially with the mail delays. There's an appeal form, a fair hearing request form attached to the grievance decision, or there should be. If there's not one, you can write a letter with the same information. What you want to specify is whether you want the fair hearing to take place in person or by telephone. It's not like the grievance where they can hold the meeting without you. They assume you will participate in the fair hearing. And in fact, if you don't participate in some way, they will throw the case out. If when you request the fair hearing, you do not specify phone or in person, they're going to schedule it by default as a phone hearing. Lastly, when you mail your request, you want to mail it certified mail if you can. So then it doesn't just get dropped into a mailbox without any tracking information or confirmation. Next slide. There's an expedited fair hearing. I'm not going to go through that standard again because it's the same standard that was used in the expedited grievance setting. You have to get the same provider certification saying waiting around 90 days. We'll talk about the fair hearing decision timing in a minute, but it's around 90 days. Waiting that time frame is going to be harmful. Usually the judge will hold sort of a mini hearing at the beginning to say whether or not they think the appeal needs to be expedited. So whether or not you've met that harm standard. Then if they think that your hearing does need to be expedited, it may be held just right after that. So, 10 minutes later, they might hang up, call you back, start over with the new hearing that's actually going to explore the medical necessity of the service. If the judge thinks that you don't need an expedited fair hearing, they're going to schedule the hearing under the regular time frame. If you get the expedited hearing, you're going to get a decision within 3 business days of when you made your request for the expedited fair hearing, which actually, I didn't mention this, can be made orally. So you can call or you can fax in your expedited request. You can't call or fax in a regular fair hearing request, just expedited. Next slide. So the fair hearing is going to be issued within about 90 days of the original grievance request, not including the time it took for you to request the grievance after the denial. There is a right to interim assistance if the fair hearing is not held within the appropriate timeframes. So for health choices, the right to interim assistance is calculated from the date of the original grievance request minus the time the participant takes to request the hearing. A minute ago, I misspoke. I said minus the time it takes to request the grievance. It's minus the time it takes to request the fair hearing after you've got that grievance decision. In community health choices, the right to interim assistance is calculated from the date the fair hearing was requested. Now, interim assistance means if you get your interim assistance request granted, you get the service or item that's at issue. So you get it temporarily until a decision has been made, which is a great benefit for people. And if you need help with an interim assistance request, the Health Thought Project is happy to help. We've done a few of them now. It's important, especially right now, because we are seeing delays and backups with the fair hearing scheduling. Next slide. All right, so to wrap up, I know we're about over time here. We're going to get to questions in a minute. These are some appeal issues that you want to watch out for. So look out for the plan failing to send out a timely notice of decision. That's going to be problematic for you if you're trying to get the aid paid pending, because you only have that 10 days to request it. So if you don't get a timely notice, you feel like, oh, it's dated November 1st, and here I am on the 10th just getting it in the mail. Check the envelope and hang on to that envelope, because it's possible it was postmarked a few days after, and we can try to remedy that for you. Look out for the plan refusing to accept a grievance request over the phone, or similarly, you make a request over the phone and they say, yes, it's being processed. Your grievance is going to be decided in the next month or so. And then you find out that they didn't actually process it. Be on the lookout for that. And Amy mentioned making sure to write down the name of the person you speak with if you request a grievance by phone, and try to get a reference number and write down the date and time of when you call. We've seen plans refuse to provide the recipient with a copy of their appeal case file. I mentioned that. We've seen insufficient notice of the grievance review date. So they're supposed to tell you at least 10 days in advance when your grievance is going to be held and how to participate. We've seen them just tell you the day before, something like that. It's totally inappropriate. So if you see these things happening, the takeaway is to call the Health Thought Project, and we can help you. We've seen the plans not include the member in their grievance meeting by phone or in person, even when they ask to be included. We've also seen these in-person grievances I mentioned, where you show up in person and everyone's on phone or video. We've seen problems with the plans failing to decide a grievance in 30 days. This is especially true right now, where we're seeing a lot of personal assistant service and nursing hours being cut in the community health choices side. And the grievance scheduling seems to be backed up. So people are not getting their grievances in 30 days. So be on the lookout for that. We've seen on the health choices side for kids, the plans classify an appeal as a rejection of a partial authorization. Amy went through that. Just be on the lookout for that. You can appeal and keep the services that they have authorized in the meantime. So it's not a rejection of an authorization in part. And then finally, we've seen the plans fail to honor continuity of services pending appeal, even if your appeal was timely filed in that 10-day window. So if that happens, certainly let us know, and we will try to help remedy that situation. And these are just a few. There are certainly other issues. Whatever issues you're seeing, if they don't line up with what you've learned today and what you know should be happening during the appeal process, flag that for us and let us know. You know, if you have a client or if you yourself are going through this process and you're not getting your rights honored, call the Health Law Project and we can help you with that. Next slide. All right, so how to reach the Health Law Project for assistance. This is our toll-free helpline number. We are open Monday, Wednesdays, and Fridays from 8 a.m. to 8 p.m. I will note that tomorrow for Veterans Day, we're actually closed, but we're going to reopen this Friday, the 13th, again, and then we'll follow our normal schedule. Our intake paralegal is going to gather some preliminary information from you when you call, and then she'll pass the case file on to either an attorney or a paralegal who will follow up with you to give advice, let you know how much involvement we can have in your case from there, so whether we're going to represent or not. And we welcome warm handoffs. So if you are a social worker, if you are a person who's working with participants or clients who are seeing these service denials and you want to connect them to the Health Law Project, reach out to us. You know, obviously, if you have permission, and just say, you know, I have this person who would benefit from your help. Could we connect you to? And we'll figure out the best way to get in touch with that person. Our helpline information is also printed on all the managed care denial notices. That's true for Health Choices and Community Health Choices. It'll say if you need free legal help, call the Health Law Project, and it should also have, I believe, some information about the local legal aid organization on there. Next slide. Okay. This is actually similar information that we just had, but this shows that the Health Law Project is here listed on the help with your complaint or grievance section of the denial notice. All right. So that's it. That's the bulk of our presentation. I know that we have some questions. I'm going to turn it over to Megan, who's been monitoring the chat for us so that we can answer some questions. And I realize we're over time, so if you have to jump off, please feel free to reach out to us. You know, we're so appreciative of your time today, and we just want to, you know, we're happy to talk offline if you're not able to stay on and do the Q&A with us.
Thanks, Dana. And again, thank you, Dana. Thank you, Amy, for taking the time to present here today. Thank you for everybody for joining us. We do have a quick, I do want to say we are going to be sending the slides out to all the participants. And we can also share this recording as well, or a link to where the recording will be. So keep an eye out for that email. We did have a couple of questions. I'm going to try to throw them out there in the order of quickness. Someone did ask, where do I find the 2020 CHC agreement?
That's a great question. It's online. What we can do is send a link to it in the materials that we mail out. So I'll make a note to do that. You can find it online.
Wonderful. And for those who are still on, there's a quick poll popping up. If you could just quickly let us know if you're interested in a more in-depth training on how to prepare your case for an appeal. We can plan even more direct, some focused on health choices, focused on CHC, if that would be helpful. But it would be great to know if a more in-depth training would be helpful to you. Another question that came up was, do you notice any difference in success rates between in-person versus phone hearings?
So that's not something that we track. However, I will say anecdotally, I tend to think that in-person is a better experience overall. That being said, I realize that not everybody can go in person for one reason or another, whether it's, you know, scheduling or a job they have or childcare, accessibility problems, even though the plans should be making any accommodation for any accessibility that's needed. That being said, I will say, you know, we see success with phone hearings. I prefer in person where we can go in person because you get to see the reactions on people's faces. You kind of get to read the room. It's just a little bit easier to present your information because you can bring your materials with you. You don't have to worry about getting them to the panel ahead of time and hoping that they get there and making sure that information is actually in their hands. So while we don't track the success rates of in-person versus phone, I would say I would lean towards going in person if you can. But again, recognizing not everyone can do that, we do see success over the phone or with video conference too.
Thanks, Jenna. That's a good, actually, just to jump off of that, with the expansion of telehealth, more and more agencies are being open to doing video. And I have heard some other families and across the state that have been having success with requesting a video hearing instead of an in-person or phone hearing. If someone did ask, if a client had a grievance, this is a person who represents patients, if a client did have a grievance and lost, they can't get the docs?
So I can answer that. So basically, there are rights at different stages of the appeal to have the documents that were relied on. So then you're relying on the requirement that the plan provide documents when there's an appeal for like a fair hearing. The other thing you can do is request the documents as with a HIPAA release. So you're really making a request for the person's medical records and records. The only challenge there is, the plans have, I think, 30 days to respond to that kind of request. What we do say, if you're dealing with someone in community health choices, we would say ask the participant to request their service plan and their assessment from their service coordinator, and also to make a request for all the documents from the plan, as under HIPAA. On the health choices on the kids side, a lot of times you can get a fair amount of the records from the nursing agency, and then what you don't have is the actual information, the actual decision making notes, but you can get a lot out of the nursing agency in terms of what the original request was and what was considered by the plan. Dana, do you want to add to that?
No, I think you hit the nail on the head. I will note, just because we launched that poll to ask if folks are interested in a more in-depth training, those are the kinds of things that we can go through in a more in-depth training. So how to prepare for your fair hearing, request discovery, what to look for in those packets. That's the kind of thing we would be looking to do in a more in-depth training.
Great. And then Vlada asked, what can CHC participants do if they do not receive a denial notice from their MCO? And it's especially an issue for the elderly or who do not speak English.
So we have seen this issue. And that's like really two different questions. So if somebody doesn't speak English, they should be asking to get their documents in the language of the preferred language. And they're not required to translate all of them, but there's at least 5 languages that have to be translated. Otherwise, they do have to communicate with the person in their preferred language. So that's the kind of case that we would take on and at least procedurally advocate with the plan that, like, the person didn't get notice or they didn't get in their language. This is not, doesn't comport with due process. If somebody doesn't get it at all, they should put in an appeal. So if they get a phone call, and this should be happening. It's not, but it should be happening, where if somebody's about to face a cut in services, the plan should be notifying them in advance and letting them know, look, this is the decision that was made. You're going to get something in the mail. They can appeal it at that moment. They don't have to wait to get the denial notice. And frankly, because of some of the mail issues, I wouldn't wait at this point. And don't let the plan discourage them from, and tell them they should wait. But if there is no denial notice, what we usually do is we follow up with the plan. And depending on the plan and the circumstances, we are sometimes able to get the benefits reinstated while the appeal is pending. What we do tell people is really, you have to keep a close eye on your mail. I think what happens to a lot of people is that the mail winds up in a pile and doesn't get looked at, and there's just so much mail from, especially this time of year, because this is what's we call Medicare open enrollment. So people are getting all kinds of mailings from all kinds of insurance companies, trying to get them to enroll in their plan. And then they're also getting this mail from their own insurance company, and it has a risk of getting lost. So the bottom line is if you are in that situation, you can contact us and we can talk to you about what the strategies could be to appeal in that situation.
Thanks, Amy. So we have notice any different. There was another question of why are there no COVID protections for CHC? And I did a semi-brief answer of, just sort of the different federal Medicaid waivers that that provided those provisions and how they sort of expired at different times. But is there anything more you would want to say about that?
So it's not actually so the state could allow the protections to continue in community health choices, but they decided not to. So we oppose this decision. But I think it boils down to the
there was no request.
Sorry?
There was no request for an extension.
No, it wasn't an extension. The state has the power. It's not related to whether there was a request or not. There's flexibilities that are built in that they can act on or not. And this was a flexibility that they had worked out with the plans to originally not reduce services, and then at the end of June, which is also the time period where they could start reducing services in a non-COVID time for people who just joined CHC. I think there was probably pressure from the plans to want to start cutting hours and reviewing and determining whether or not, doing assessments again.
Gotcha. Thank you. There is another question. PAHW is trying to decrease my PAS hours. If those hours are primarily being covered by a family member who lives with the participant, can that affect a grievance?
We look at those cases. That's something we would look at on a case-by-case basis. So, so there's federal regulations require that services be provided voluntary, at least most services outside of things like housekeeping. But we know that MCOs on the CHC side do look at whether or not somebody has what they call natural or informal supports and are increasingly relying on this without any kind of assessment about whether the person who they're wanting to rely on is capable or able or willing to do that. So we would say that it's a factor, but we do take those cases, and it's something we're looking very closely at and are concerned about.
So definitely the recommendation would be for that person to contact PHLP.
Yes,
great.
Definitely.
We're at 11:15, and I appreciate Amy and Dana, you two taking the extra time to answer some questions. I appreciate the attendees that stayed on the line. I think at this point we'll wrap up. If there are additional questions, please feel free to reach out to PHLP at what was provided on the slides. We will be sending, as I said, just sort of a blanket email with the slides and some additional information to all of the participants. And that will give you the email addresses of myself from Pennsylvania Families Need Nurses Now, Megan Lechkowski, if there's anything I can be of help with. And then also the folks at PHLP. So hopefully if there are any open questions, we can help you with those after the fact. Once again, I appreciate everybody's time. I hope this was very informative. It looks like there was an overwhelming yes, resounding yes to wanting some more in-depth training. So we'll plan those accordingly, and we will be sure to let everybody know when those are happening as well. So in the meantime, everybody stay safe, stay healthy, happy upcoming holidays, and we look forward to connecting with you again soon. Take care.